what the hell's the point in a holster? If you can't carry it.
You can carry it outside, exactly.
Yeah.
So this just comes to show that there are parts of the opinion that sort of make sense.
Yes. Welcome to episode 3 of the Lawish podcast. We're back, and this time we took a brief break. Had a slightly, I think, lighter episode last time. Fortunately, we're back to a more serious but important topic today.
We're masochists. We love. we don't shy away from the difficult discussions, and today we're bringing a doozy.
Absolutely, and this impacts obviously a lot more people than Amber Heard and Johnny Depp. So.
Well, I don't know about that, bro. I was following that for all those 7 weeks.
This is true. I guess it impacts in a different way. But we're going to be discussing a newer case that came down right before the Dobbs decision. Just as controversial, just as heated. And to a lot of people, probably they see as being just as important, I guess, as the Dobbs decision. This was the New York State Rifle and Pistol Association versus Bruin. It was decided in June. It really just expanded the Second Amendment. But before we get there, we want to kind of talk about what the Second Amendment is, how the courts interpreted it in the past, what it does and does not do, and kind of how we got to where we are now. And we want to do that in a way that's kind of brief. We don't want to dive too much into the prior cases, but at least touch base on kind of what the decisions were so it makes sense. People know where we started at prior to this decision coming down. Yeah,
this is one of those where we could very easily take just a handful of episodes or, of hours, if you will, to just talk about the background and all the different cases throughout history of recorded constitutional law decisions, but this is not the place for that. Because then it would stop being entertaining, as entertaining as this could be. It would stop. It just really dense, echoing what you were saying. This is an interesting, relevant topic. Is just as controversial as Dobbs and the Roe v. Wade. Because it fundamentally goes back to, what do you have a right to do and not do? So it's something that we ought to talk about.
Yeah. And I think it hits, especially kind of closer to home for Americans based on, obviously how our country was founded. So, yeah, it's very important, obviously, to a lot of people. Given what's going on now, obviously it's there's a lot of passion all over surrounding it, but we'll touch base on the Second Amendment in general. I'm just going to read it. I think it helps kind of give background, and also it's going to be relevant when we start talking about the case itself and kind of how we got there. But the text of the Second Amendment says, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now, there's been a lot of debate on what those words mean. Prior to getting to this case, and even in the decisions prior to this case, the first kind of landmark case in the Second Amendment line of cases was Heller. DC v. Heller was decided in 2008. It was a 5-4 decision. So again, it was a very close decision. Ultimately decided that, ordinary law-abiding citizens, which is important, will be important later on, the law-abiding part, the Constitution, specifically the Second Amendment, allows ordinary law-abiding citizens to own firearms for self-defense inside their home. And that they kind of get there through really focusing on the right within the Second Amendment, reading specifically 2 portions, the right of the people to keep and bear arms. They really focus on that. Basically determining that the right of the people really just applies to everyday American citizens. And then to keep and bear arms, obviously being firearms. But then they also read the security of a free state as in that's kind of the self-defense portion of it. We had spoken about this prior. I personally don't really get this. Especially from a textual standpoint, which is the current sitting court, is very much a textualist, originalist kind of approach to interpreting the Constitution. It says a well-regulated militia, which to me means at least a group of individuals that are performing some sort of military exercise or action. Not really applicable to any single citizen, but more of collective if there was a need. That's followed up by being necessary to the security of a free state, which again, I take that as being free state being the United States, and specifically based on how we were founded again,
right?
Fighting against, oppression, breaking away, forming our own country, a king, tyranny. I take this as being really just applicable to Americans in the sense that if they needed to defend the nation against the tyrant, and the militia would be able to do that, and obviously you would need firearms to do that. So anyway, they kind of take a interesting approach on how they get to this applying to individuals. They look at some history. They look at farmers used to use it to protect their property, which I think makes more sense when you look at what Heller ultimately decided when they say you can keep a firearm for self-defense in the home. Because there's an argument that if you were outside on your farm, and that's really what it was kind of referring back to, if somebody would try to steal somebody's property or take over the farm or something, that was still your property, that's still kind of in your home. You're not walking around, going down the street, going somewhere else with that firearm. It's just if someone were to go try to take your property, whatever it is, from you, you could defend yourself. So I think it applies in those situations. But I don't think that reading alone, especially focusing on that, then means that expands to you can carry a firearm anywhere. But,
right. And it's important to note here that the reason you're heading down that path in your introduction is, there's all this context about why it makes sense for you to keep your guns at home and be able to self-defend. King of the castle doctrine, right? Yeah. You self-defend your home and your property, but that doesn't expand necessarily to out there in the public. Yeah, and the reason you're going there is because this particular case that we're going to be discussing in a little bit more detail focuses on that. Well, one, whether there is really a right to carry, like that right carries outside into the public, and if so, whether states and governments can regulate that and essentially create an impediment for you to be able to carry.
Exactly. Yeah. And Scalia even went so far as to say that he read what I just read, again, I'll read it again. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms should not be infringed. He said that should really be read to say, guarantee an individual right to possess and carry weapons in case of confrontation. I don't get how you get that from that at all. And I'm not saying I disagree.
It almost feels like glossing over, at least for someone who hasn't necessarily looked into that specifically, the militia part. Right?
Yeah.
Because, like you said, in the context that you provided about how the country was founded and the situation, the circumstances in which the Constitution and the Bill of Rights and the amendments were created, you think, well, you know what? We don't want what happened to us back in the day, even back then was still relatively recent, to happen again. We have to be able to have arms to defend ourselves from tyrants, kings, invasions, whatever the case may be, to keep our independence. And I believe there is some reason for the introduction of the word militia. Mm-hmm. Like you said, now a militia could be a group of people. Yeah. It doesn't necessarily have to be the military. But to your point about how Scalia got there, and we'll talk about this in the New York Rifle and Pistol Association case, how they also make, not necessarily in this case, but in the previous ones, they said, oh, we also found that militia does not mean the military, means a person.
Yeah.
And at least I find it hard to believe, if you're trying to be textualist, where do we interpret a militia to be one person?
Exactly. And I think there's an argument, obviously a militia doesn't need to be military, like the military.
Right.
But more so an organized group of individuals who are fighting for a cause.
A group, as opposed to a singular person. And I agree with it, because even if you think about that, there might be times when you're trying to defend yourself from the military.
Yeah.
So I agree with you that it's not necessarily interpretation of militia being the military and that's the only people that can have guns, because there might be situations where the military now falls to a king, and now you need to defend yourself from the military. I can see the term militia used in the context of a group of people. I still have trouble finding it to interpret it to mean one person.
Exactly. And it's weird because Scalia in Heller says that, this central component of the Second Amendment is self-defense, like individual self-defense.
Right.
I don't know how you read that. And to me, the main purpose from reading that, from a textualist standpoint, in my opinion, is it's basically just to prevent tyranny, to prevent what happened originally, the reason we broke away and formed our own country in the first place from happening again. But nonetheless, it doesn't, the court ultimately gets to that conclusion, determines in Heller that there is at least a right, a constitutional right to own a firearm for self-defense in one's home. Later on, McDonald v. Chicago follows up Heller. They decide that the 14th Amendment applies to the Second Amendment, basically saying that it just applies to all the states. So it's not just a government, it applies to every state, regardless, all the states in the Union. And then we ultimately get to New York State Rifle and Pistol Association v. Bruin, which was decided in June of this year. Interestingly enough, between Heller and McDonald, and even prior, people have kind of, which I get the court kind of touches on in this, have, by and large, most states, people have been allowed to carry outside the home. So while it was never decided that that was a constitutional right, it was happening, and it's almost like the court kind of embraces it in part because of that. There's a long-standing tradition within the United States of doing so.
Even at the time of this decision, they mentioned that there's 43 states right now that have, what they call shall issue statutes, where it says, they can regulate the requirements to obtain licenses, but they cannot deny you a license to keep and carry the way this statute was trying to.
Exactly. Yeah. And so that brings us to here. Yeah. So with the shall issue, as long as you can meet those requirements, you can get a gun. Yeah. They can't prevent you from getting it if you can meet whatever the state requirements are.
That's an important distinction when we get a little bit deeper into Bruin, because, and the court calls this out a couple of times, in these 43 states, in what you call a shall issue state, that means, like you said, if you meet these requirements, the state needs to give you a license, right? For those of our listeners who are not familiar, those requirements could be a background check, certain age requirements, like for both the sale and the possession of a gun. I think possession federally is 18. You cannot possess a gun if you are younger than 18. You cannot buy a gun, or you cannot be sold a gun if you're younger than 21. So these requirements, and that also some states may enact.
Well, handgun at least.
Well, handgun, yeah, correct. And that could also be background checks, mental health checks, prior criminal history, things like that. That a state can say, well, you know what, you get, I guess, no longer fall within the law-abiding citizen piece that then umbrella that gives you access to the Second Amendment. In this case, New York was part of 8 states that, as opposed to the shall issue, where may issue.
Yeah.
And in this case, it was, well, if you meet certain requirements, we may issue a license for you to carry a gun. Where I see a problem, and I kind of felt like New York set themselves up for this, overturn of the law, was that their requirement was, in my view, really ambiguous.
Yeah.
It's like you have to show, what was it, like, what do they call it? I think it was like proper cause or something.
Yeah, it was proper cause, but it was also like you had to have some sort of like substantial need, basically.
Right, exactly. And based on the language of the opinion, it was almost like you needed to be on the verge of being killed by someone specifically targeting you, not just crime in the general area, in order for you to be like, okay, that's proper cause, let me give you this gun.
Yeah.
And when you have something like that is so burdensome for a regular law-abiding citizen to get to, you're kind of setting yourself up for failure when it comes to, specifically in with this court that is so conservative and so textualist.
Yeah.
You're setting yourself up to get that law struck down.
Yeah, 100%. And so Thomas writes the opinion in this, not surprisingly.
Your favorite justice.
Definitely my favorite. He opens by just talking about, basically says that everybody's in agreement in this, in this case that people should have the right to carry their a firearm outside the home for self-defense. Now, they disagree as to whether New York's law respects that right. Interestingly enough, prior to this, there have not been a decision saying that anybody has a right to carry a firearm outside of their home for self-defense. It's been happening. A lot of states allow it, but there's been no Supreme Court decision saying that, that's a constitutional right or that's found in the Constitution. It's been limited to one's own home for self-defense. But it's not at issue here. No party's arguing that, that's not the case. So the court agrees that that is the case in this and says, we agree with both parties, but without actually doing an analysis, because it's not even at issue, of course. So I get that. But then they start to focus on New York's law, the whole may issue, but specifically New York's may issue law, and really take, again, that originalist textualist approach, or at least the analysis is one that's done in that way. And they look through history and tradition. And this was notably a 6-3 decision, like Dobbs. Again, we have the conservatives and the liberals basically breaking across political lines, essentially. They view history between the 1700s and the 1800s. They both, the dissent and the majority, do an analysis based on history and tradition. They come to different conclusions.
No, this is worth noting that this analysis of history and tradition is quite substantial, as opposed to, for example, the one in Roe v. Wade or the one in Dobbs overturning Roe v. Wade. This one went to some extremes. The precedent was from anywhere from the 1200s to the 1900s, and so the court decided to humor them. Thomas has this snarky way about him, where he was like, "Whoa, let's look into antebellum, postbellum, and then medieval times and all that stuff to try and, I guess, humor the government." But man, that look into that whole history and tradition, he took it quite literally, and it's pretty extensive.
They go back to English common law, medieval times, the colonial period, antebellum period, so like the
post-Civil War.
They go into just recently.
They get to the 19th century, they're like, oh no, that doesn't count as much though.
Well, and that's it. So they ultimately settle on this period, that basically they say it can't be too old, it can't be too new. Okay, we can't really focus on before the Second Amendment was enacted because, well, there's nothing really saying the Founding Fathers cared about that, the Old English common law. Even though we do the same analysis in a lot of other situations and we do take that into consideration, we're not going to do that here because they say, that was before the Second Amendment, which makes sense, right, to a degree.
Right. There's an argument to be made where it says, if you're looking at a law, you're trying to interpret it by, in the context of the times when it was passed and when it was enacted. So I think to that extent, I agree with that. And
then there's some cases. New York's like, hey, this law has been on the books for a century. Since the late 1800s. It's not new. Like, the mayor, I think, even said, like, is this not far enough back in history and tradition? And it's like it's been this way for 100 years. But then the court's like, well, that's too new, right? That's after the Second Amendment. That's not. It's kind of like this Goldilocks period that they really focus on, which is right around when the Second Amendment was put into place.
Not too far back, not too far forward after that.
And what did the Founding Fathers, or what was the sentiment in the states at that time, as far as how we could regulate firearms and to what extent the state could do that? The issue is, even within that period of time, there's a lot of conflicting information. There's laws that did regulate, similar to kind of what we have now. There's laws that were a lot more laxed, and so that's where. But then Thomas is kind of like, there's those laws, but those were too kind of like sparse. There weren't really enough of them. Those were the outliers, so those aren't really matter. We're not going to focus on those. Some of the laws were even in Texas, which surprisingly, some of the stricter laws, and he's like, we're not worried about that. So. They certainly pick and choose, but their approach is they're like, look, this is the period of time in this analysis that's the most relevant because it's happening around when the Constitution was enacted, the Second Amendment was enacted. that way, therefore, that's the relevant time period to really kind of say what was happening at that time and what was actually intended by the founding fathers for the Second Amendment as far as the regulations go. So they take this again, view back, and they're like, okay, this is the time period we're going to do this because of, history and tradition. This is the most relevant. But we don't want to do any of this newer stuff. We want to, use a historical approach. But then they do use the future, and they acknowledge that, okay, well, we're textualists. The Second Amendment says this, but obviously it's got to change with times. And
I literally got a quote. I was trying to go through my notes again, and I literally got a quote that speaks specifically to what you're saying.
Yeah.
That I highlighted that says, although its meaning it's fixed according to the understandings of those who ratified the Constitution, which we're talking about in the context of when this was happening, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated.
Yes. Yeah.
But at the same time, it's like, well, but not those. Not
exactly.
Those. So we should expand it to beyond what the context when it was passed to encompass those situations that they didn't anticipate it, but also don't go crazy.
Exactly. As long as it benefits whatever ideology we have and we're trying to do. And the irony in that is, Breyer touches on it later in the dissent, but, it's like, okay, you're expanding this to apply to handguns from obviously muskets or whatever, archaic weapons you had back then.
Crossbows.
Crossbows. And, and more modern day weapons.
Slingshots.
But interestingly enough, too, right, Spears. Thomas is like, he says actually, I'll just read it because I think it's kind of funny here. He says, Second Amendment extends the prima facie to all instruments that constitute bearable arms, even though those that were not existent at the time of the founding. But then he goes on and says, arms is fixed according to his historical understanding, but that general definition covers modern instruments that facilitate armed self-defense. So what is armed self-defense? That's a pretty broad, category. And so to me, it's like, is that something you could just
I could just bring a bazooka and be like, this is my preferred choice of
or it's got to be something you can like conceal, so you can walk around with like a Uzi or something, or
the preferred choice would be obviously a katana. A katana would be like the best.
But no, the main point is like,
you also look cool, and if you have a fedora,
yeah, dude,
that would make it even better because not only are you defending yourself, but you're also very attractive for females.
Oh yeah, it works every time, man. I mean, the main point is he expands the Second Amendment, or he takes an interpretation of the Second Amendment, is expanding to develop with time, but only to what you can carry as far as what types of firearms and stuff. But then doesn't really see the irony in not changing at least or viewing differently how you can regulate those firearms with the changing society. So he acknowledges weapons change, society changes, but then we're in a much different, much more populated world than we ever were, and the states, you're not in farms, you're not in there are farms certainly, but like you have cities, you have people that are like, everywhere, and it's like we're in a completely different world. So, but again, it's the court kind of picks and chooses what fits their own ideology.
On one end, you're saying the Constitution and the text should evolve with the society. Mm-hmm. But when you look at a problem that occurs now because of the way society is right now, it was not contemplated before. They could have solved that problem before and they didn't. Yeah. That means this is not the solution.
Exactly. And I think what you're seeing with the current sitting court, as opposed to, prior to the three new conservative textualists, originalist justices getting on the bench, is there's less of an emphasis on the state's interest, and more of, okay, what does history and tradition say as far as the Constitution? What did we used to do? And unfortunately, what that seems to be doing, I think, to some extent, is, a large part, is we're pulling away from kind of a lot of common sense, and also what is best, again, something we discussed kind of this previously, but what is best for society as a whole, as far as, modern day times. And then, well, what did the Constitution say? We got to stick to that. And it's like, if we can't change and that can't develop with society, it's no longer really working for the people at that point. So
it's going to hinder progress at one point in time. And just to be clear for our listeners, both Jeff and I are pro, the right to bear arms.
Absolutely.
So we just kind of differ in the way some people look at it, whereas like
Yeah.
it's just like an unfettered right to own assault weapons for assault rifles
Yeah.
for no reason, versus having them for self-defense, whether that be defense from regular crime from other people and defense from a government, a tyrant.
Yeah.
So just I thought it was worth pointing it out that our discussion here is not in a way that is like, oh my God, we should ban weapons and take everybody's guns away from them. That's not it.
Yeah, and I think to that point, like again, I don't think as a reading of the Second Amendment, I don't agree with the court's reasoning in Heller. I don't agree with the court getting even to where we are now. But I do think we should have the right to bear arms for self-defense and in case, there were some sort of need if there was a takeover by the government or tyrant or some situation where we had to, but I think my issue is it seems like they expand the Constitution and the reading of the Constitution to a way that I believe makes sense to modern times with self-defense as well as the ability for us to defend ourselves against a potential tyrant. But then they won't do that in other situations because it doesn't fit the ideology. So I do think the reasoning is bad in my opinion for the most part. But I do agree we should have that right.
You're making the case for a way to interpret the Constitution, but in making that case, you're also pointing out that in your view, their interpretation so far, at least the last couple of cases, has been hypocritical.
Absolutely.
Because wherever it suits you, if you will, you're reading it one way, and where it doesn't suit you, you read it this other way.
Exactly, and that's my main issue. It just seems, and it's certainly not
because you don't have an issue with the way they came out here, and I don't either. To an extent, I'm like, it kind of makes sense.
Yeah.
And specifically when it goes to, for clarity's sake, to the extent that the court is offering their homework, when they show their work, I think there's good arguments buried within this.
And if you do, putting kind of the bias aside, that time period they focus on, I do think makes the most sense.
Yeah.
Obviously, the time period around when the Second Amendment, was enacted and our founding, that's going to be more relevant than anything that was newer from a textual standpoint, originalist approach, or prior to that. So, I mean, that 100% makes sense from that analysis. They do leave out, again, laws that contradict what they want around the time, but, ultimately, that's something that kind of Breyer really hits on in the dissent. Is he's like, look, it's ambiguous at best. There's nobody really could come to a consensus at all at any of this historic, regardless of where you look in history. There's things contradicting each other. And it's like, as justices, you're not historians. So even historians don't really know. Which brings us back to, again, the kind of abortion situation, where it was like, doctors don't have a consensus. Historians don't have a consensus on what was or what wasn't, really regulated and to what extent it was back then. If they can't agree, how is the court going to make that determination? But nonetheless, when you're a textualist and originalist, that's what they try to do. And he makes a comment which I thought was funny. He says, as a result, history, as much as any other interpretive method, leaves ample discretion to look over the heads of the crowd for one's friends. Basically just saying that, you're picking and choosing whatever benefits you in history and your ideology. And again, I don't think that's tied specifically to the conservative justice by any stretch of the imagination either.
I agree. I think we talked about this before. But justices being human beings and then they themselves having personal opinions. The job of a lawyer is to use words and interpret laws in your favor. Yeah. That really, and whether you can convince a judge to fall in your favor because your argument was just more persuasive, that's great. Yeah. There are plenty of examples of a good attorney winning a case with a really bad argument, so long as they can articulate it in a way that is persuasive enough, even though they're wrong. Yeah. 100%. So the problem here is the justices don't have to convince anybody. Yeah. They as long as you have enough votes to put out a majority opinion, that's all you need. Yeah. To your earlier point, though, I think there's an argument about the difference in this interpretation, or in the interpretation of this case and Roe v. Wade. And I think it's an argument that is important because in this case is, well, yeah, the difference here is the Second Amendment as such is written in the Constitution versus the right to an abortion is not. So what are your thoughts on the way the court addresses that?
I agree to an extent, obviously. But I guess, again, it just depends on what side you're on, what your argument is, because the court in Roe v. Wade certainly found a way to say it was essentially written in the Constitution. And then there's also a reading of if you take that approach, the Second Amendment, I don't believe, as read, provides the right they're saying it provides. So I think they're doing the same reading to an extent as Roe, just as Roe did, to find a right to, a woman to have an abortion. So I don't know. I think, again, the justices are taking a lot of liberty in how they're interpreting the Constitution to fit their ideologies. And I find that to be very similar as to what happened in Roe. And so it's just depending on what side you're on, I think. I mean, there is an argument. There is, again, a Second Amendment that does mention firearms. And to some extent, self-defense. That's really kind of, and that's interpreted, though, in ways that I don't believe, if you read it,
you think it's interpreted in a more of a expansive way than it is meant to.
Which is what I find, again, with a lot of the privacy rights kind of came about. There's this need in society, and as people, we think we should have that, as a civil society. Women should have control over their bodies and all the other privacy rights to make a fair society. And I see that happening kind of with this. They see it as being necessary, and I agree. It is. But I just think they're kind of trying to have it both ways, in my opinion, to whatever fits their own.
I think that's a fair argument.
Beliefs.
I think that's a fair argument that it becomes problematic because then for some opinions, making decisions on some issues, you can then, and by you I mean the court, can rely specifically on, well, let's go back to the text of the Constitution. It's not there.
Exactly.
Let's go back to history and tradition. It's not there. Sorry, not a right.
Yeah.
And then for this, it's like, well, the intro to weapons is in there. History and tradition expands it into what we wanted to say today. So it is there.
Well, exactly.
and that just gives you the ability to pick and choose what doesn't apply.
And they essentially say something along the lines of like, there's nothing in the Constitution saying that you can't do this, that you don't have essentially like unfettered right to carry outside to an extent. But it's like, that's not a textualist, analysis. They're just basically saying just because it's not in the Constitution, or since it's not in the Constitution, that, it's a right. But then again, we get to abortion.
They're taking the absence of it as permission.
Yeah. And that's
but then they took a different approach when it came to abortion.
Exactly. And that's certainly not the textualist way to it, analysis, or at least how it should be done. So the court goes all over.
That would make them the Constitution like an exclusive type of document, right? Where it's like anything that is not in the Constitution,
it's fair game.
You can do. Yeah.
Exactly. So
it really is a guideline for nothing. Really, exactly. It doesn't help society in any meaningful way.
It's kind of crazy. And then then he touches on, Thomas kind of digs into Breyer basically in the dissent, saying that like, they talk about all these mass shootings, school shootings. Kind of says like, look, that's sad, but it doesn't really matter as far as our analysis goes. As far as whether it's a right and to what extent that right should be able to be regulated. The issue with that is, though, again, then he points out in the analysis itself, and Leto does in the concurrence, points out, he says that, he digs into Breyer too, and then he says, well, there was this case where, this lady robbed this person, or this person was shot and killed, or somebody was raped.
Or someone was about to be raped, or
But then it's like, and so then you're using this kind of a emotional, in their words, kind of like feelings approach to it, but you're doing that to fit your agenda and justify, the right to carry outside the home. But then you say, oh, why are they doing it? It doesn't matter. And it's like, again, you're having it both ways. It's kind of almost like a reduction in the state's interest as far as when these analyses are done, to an extent. Because certainly mass shootings are a huge interest to the state. Any sort of gun violence is a big issue, should be a huge state interest. But they're kind of really downplaying that and saying, well, yeah, but it's constitutional right. Too bad, in a way.
Yeah, and Alito, I think this is a really hard case to read.
Yeah.
And make peace with as much as you can. To an extent, I agree with Alito when he says we're answering the question of whether the Second Amendment right to carry and bear arms extends to you being able to do it publicly in a way that cannot be encumbered by New York's poorly drafted law.
Yeah.
And he's like, we're answering that question, period.
Yeah.
I agree that him using then the other arguments is kind of like, well, you're defending your own point, right? But to that extent, I agree. But then it's hard to, again, find peace with that when I agree with you 100%. Like, these mass shootings have gotten out of control. Yeah. On the flip side, then also it was like Alito saying, do you think the Buffalo shooter would have cared that carrying these guns out in public was illegal? Or do you think that some other person who has really mental issues cares about the legality of having this gun, and then before they go out and conduct a mass shooting?
Yeah.
And to an extent, I agree. Well, yeah, they obviously don't care. I mean, I think that if you read some of the news articles about the Buffalo shooting, the guy literally says, "I'm gonna go and do it in this particular place because of the laws they have for guns." Yeah. So that, and in this case, if I recall correctly, so forgive me if I'm not, but I think there was something along the lines of, "I'm gonna go and do it in this place because that place has stringent gun laws." Meaning there's a lower likelihood that other citizens will be armed, and then they're going to shoot me. So essentially they wanted to be the only ones that would have the gun, albeit
for sure
illegally, right? So I think that is a point for that argument.
Yeah.
It makes sense, but it doesn't really do anything to reconcile the hypocrisy that we're seeing in how you interpret the Constitution, whether we agree with the endpoint or not.
Yes.
Are you using the wrong means to justify your ends?
Like, I think that's ultimately it. Like, I agree. I think New York's law in this situation is way too strict and too burdensome. But I do think, to that point, Alito and Kavanaugh both tried to bring some clarity to the situation, which is ultimately kind of where we're going now, and saying, hey, look, this doesn't mean states can't regulate guns at all. But the way Thomas said it, of course, it's got to be done in the way that it was done in history, essentially. But they say that shall issue regimes are still constitutional. They say those are allowed. You certainly can do stuff to, have requirements that people need to meet before they can get that license. But you can't then just be like, well, you met all of our requirements, therefore we still don't want to give you.
It's our discretion to still not give you one, Yeah,
and I think that's because, obviously if you're reading it, it's saying that it's a constitutional right, then you have that right. Unless, as long as you give me whatever the state requirements are. And I think, too, it's kind of like taking an analogy, like if you think about the First Amendment, and they were like, okay, you can't speak in certain areas or certain types of speech somewhere else or whatever. You can restrict to an extent what type of speech you can do in certain areas. Well, but they're like, okay, you can't speak because you're liberal or whatever. You can't speak because you're conservative. Like, that'd be like similar to that. It's like you have the right, and as long as you meet whatever the criteria that should apply to everyone for the large part, it's like you should then be able to exercise that right. So I get that. I think an issue I take is Alito's using that example that you used. I think I agree. That makes sense. The issue then is, though, how this is going to potentially apply to like things like red flag laws, things that like the Senate bipartisan bill covers that literally were passed by both parties in Congress are now at issue because of the Supreme Court decision.
Are they though? And that's a question. I'm not arguing that they're not. What I'm saying is, if we interpret the bipartisan bill to be a shall issue, if you meet the requirements established by, in this case, the federal law, you have the right to have the license. Yeah. But then, by virtue of passing this law, which essentially is the requirements, wouldn't then you be able to make an argument that, hey, you know what, this person didn't meet the requirements, so I don't have to issue the license?
Well, yeah, but the red flag laws are, you can already have a license. Yeah. Then it gets brought up. Basically, I could call if you had a gun, and I'm not, and you say like you were talking about killing somebody or something. I could call the police and say, hey, I'm worried he was talking about killing somebody. They could come take your firearm for a brief period of time while there's a hearing and stuff, if there's a risk of harm to yourself or others. But at that point, you already have the license.
Yeah.
You would already have it. So,
But then, I mean, licenses are not irrevocable, and perpetual. So
Yeah.
you can make the argument that, you know what? At one point, if you fail to continue to meet
I
the
know,
requirements
I
for the
know.
license, I think that there's an argument
we'll have
here.
to see. It hasn't been challenged yet. You know, who knows?
It's going to have to be one of those that is,
yeah.
in practice, how does it actually work?
Yeah, exactly. And it's going to be interesting to see that. I think what you're going to see states doing, especially the may issue states now, is just trying to add as many restrictions as they can to make it as burdensome as possible.
Right, which that in itself, it's going to find its way through
it's going to be right back up to the Supreme Court.
Yeah.
And then, I mean, aside from that, yeah, they can regulate things like, giving more mental health resources and community like engagement and whatever you think is going to help to kind of drive at the underlying cause of gun violence, in your opinion, or whatever. But yeah, as far as their ability to regulate firearms, it definitely is limited to a degree. But I think personally, I agree with the court's outcome 100%. I just think they got there in a way that their analysis was very shaky, kind of having it both ways, and certainly wasn't something that I had confidence in when reading. It certainly seemed like they were just interpreting whatever they could to feed their own.
They were trying to find the means to justify the ends. The one thing that I'll say, for as much as I don't necessarily agree with the way Thomas even drafts any opinion, including his dissents, there was one item where he said, and I thought it was hilarious when he goes, it kind of makes sense to interpret the term "to bear arms" to mean carry publicly, because, and then I'm gonna read this. He says, most gun owners do not wear a holstered pistol at their hip in their bedroom or while sitting at a dinner table.
Yeah.
I guess when you're just trying to think about it in a commonsensical way, right?
Oh yeah.
But I just thought it was funny.
No, it is, and I agree. I do think though it kind of goes back to what they were relying on. A part in their decision was, again, farmers protecting their farmland. Well, if you're out on your farm, you'd have it on your hip, right? You're not gonna have it in your house. There's people coming for my cows or whatever, Let me go inside and grab it. But no, I mean it is some comedy in this. Not that any of this is really funny, I guess, but in his opinion, it's obviously, what the hell's the point in a holster? If you can't carry it,
you can carry it outside, exactly.
Yeah.
So and again, this just comes to show that there are parts of the opinion that sort of make sense.
Yeah.
The foundations for the ends that they reach, the conclusions that they reach, are, like you said, are kind of shaky, are kind of weird, are self-serving, definitely. And as much as we agree with the final conclusion.
Exactly, and a lot of this happened prior. Again, Heller and the interpretation of the Second Amendment and what it applies to, that was already prior to this case. And so that's a whole other issue if you take issue with it, obviously. But I do agree that the time period they focused on here does make the most sense.
So I think before we move on to the final piece, I think, which should be what this is and isn't, what the opinion means and doesn't mean. Let's talk briefly about why the New York law itself was essentially, prone to being struck down. Yeah,
so the New York law, it's a May issue regime, as they call it. So basically, you had to meet whatever requirements they had, background check, fingerprint, whatever else they had you do. Once you met that, it still didn't mean you got to carry, to carry the firearm. You had to show that essentially you had some substantial need to own that firearm. And in the case, the individuals who brought the case originally lived in what they considered a bad area, high crime area. And they were like, hey, I want to be able to carry this gun on me because I live in a bad, high crime area, basically just to defend myself. And they wouldn't give it to them. They basically said that wasn't enough. Just because there's a lot of crime in your area doesn't mean that that's a special need or you've shown
proper causes, which is what they told him.
Yeah. So that was, that wasn't enough. And then it was kind of like, they talk about situations where ex-judges, because judges might be out to, people might be out to get them or whatever. Certain very or security guards that are going to work, very job dependent, police officers, And so it was kind of really nobody it could really meet that threshold. So it was essentially banning firearms, at least concealed carry, to be able to carry them outside the home.
No, I agree with you. I think there was another, again, going back to the parts of the opinion that make sense, that are logical. I think Thomas closes with something that I highlighted here, which says, "We know of no other constitutional right that an individual may exercise only after demonstrating to the government officers some special need." So it was going back to those where it's like, if you have a constitutional right, the government may have an interest in making sure that you exercise it responsibly.
Exactly.
But they cannot put the burden on you. Tell me why you need this gun. It should be you, the citizen, asking the government, tell me why I shouldn't have this gun. Yeah. Right? So I think that kind of just compiles into the reason why the New York law was bound to be struck down.
Imagine if you had some obscure religion or whatever, and the government didn't abide by it, and like, well, tell us why you should be able to exercise that, right? So whatever, like pray in this, whatever. It's like that sounds ridiculous. If you apply it to any other, right, and again, you could obviously argue you don't believe it is a right. That's a whole other issue, but the way they're obviously going about this, it's like, then it wouldn't make sense. You either have the right or you don't. And certainly you can regulate it. You can put restrictions around it that, to an extent. But it's like, this is effectively just getting rid of it altogether. New York went too far, essentially, is what the court's saying. But they point out again, you can regulate kind of the threshold to get that license, what requirements need to be met. Again, you have to be law-abiding. You can't be a felon potentially in states. You can't.
You can have a history of mental
health.
Mental health, and I don't think that they meant to discriminate against people who suffer some sort of mental health. But it's like you cannot have mental health issues that give rise to the probability that you're going to harm someone else or yourself.
Yeah, and there's actually been cases that were brought for that. Ultimately, it didn't go in their favor. They weren't hurt, but because people said it was discriminating against people who are mentally ill. It's like, well. In some situations, obviously, it makes sense.
The interest of the state is like quite compelling there.
Yeah, and waiting periods. So there's that kind of stuff prior to getting a gun.
The states can still regulate how they issue these licenses, but there's two important aspects to this. One, you can set your rules, but you got to follow your rules. And then the second point is, one of your rules cannot be your officers or judges get to decide after the fact with discretion. Well, you met the rules, but also you lose.
Yeah, you're essentially, one, you're picking and choosing who can and can't. And then you're also, it's kind of like you're like making it look like you can actually carry.
It's illusory.
Yeah, but not really, and it's.
Oh, you absolutely can get a license, but no. Yeah. Another point that you touched on briefly, which was the states have still the ability to regulate where you can carry these guns and essentially create what they may deem to be sensitive places. Yeah. So what are sensitive places?
Well, the court doesn't really tell you. That's
right. Thank you for listening.
So they point to what has been recognized in the past. They say government buildings, courthouses, churches.
Right.
They don't really say.
They tell you what it's not, and that is the island of Manhattan.
Yes.
That cannot be a sensitive place.
We know specifically the entire island of Manhattan cannot be categorized as a sensitive place. I think subways is probably going to be something that comes up relatively soon, because the shootings that are happening in subways. In our current court, being conservative, I find that subways probably is not going to fall into the sensitive places. But who knows? Who knows? I do still think government buildings, churches, schools, I honestly, I don't know, given how things are going. They'll probably just leave it up to the states, to regulate anyway, which is already is. So, but yeah, I mean, it'll be interesting to see. But there is, I think, they just kind of touch on what's been recognized in the past, and they say, hey, look, the states can still regulate in specific areas that are, considered sensitive places. They don't really provide a whole lot of guidance on what that is, but other than touching base on what's kind of been recognized in the past. But, so there are things they can do. There definitely, states are limited much more than they were for the past 100 years. Again, this was since the late 1800s. New York's law has been in the books. So it is a huge change. And I get, people that are obviously, hopefully everybody is bothered by the gun violence and mass shootings and school shootings. So I certainly get the frustration. You're like, look, the little things we're trying to do to make progress, a lot of that even potentially is at risk.
Yeah.
And then we're just expanding gun rights at a time where a lot of the country thinks we should have more, gun restrictions.
Control. Yeah.
So I get that 100%. I do think, though, the reasoning in this, based on how they went about it, was, albeit confusing and certainly at times very,
contradictory,
political, or yeah. But I do think they ultimately, it makes sense the way they approached it, and I don't want to get too much into, this is my personal opinion, preface for anybody who's, wondering. I hear a lot of people on the left, again, they're frustrated. A lot of people who think that the Second Amendment, basically people shouldn't be able to carry firearms at all for self-defense or otherwise. And I've also heard people on the left say that, basically we don't need it to protect against the government. That two things. One is that would never happen. There would never be a government takeover. I think it would do them a lot of good to look at January 6th, which a lot of them probably feel a certain type of way about.
That's a very optimistic way of looking at things. When it comes to like you thinking, the government would never do it, it's like, well, history would tell us different, and not even just recent history. Definitely recent history does, but
yes,
history will tell you that once you give too much power to someone, unfettered power, that's just a recipe for disaster.
Exactly. I mean, that's how the country was founded. And so there was a very real concern, and people who are concerned about that, I think, is very legitimate. And there's the whole thing, oh, well, how could you, defend, again, the argument, we don't need anything more than a rifle and a handgun for self-defense. And I think, again, if we're looking at it from what I honestly think is the main reading of the Second Amendment, it is to prevent from government takeover, a tyrant or whatever, and in that situation, you're going to be a lot better off with guns that aren't handguns and rifles if you're fighting against the military. Now, I'm not saying you should be able to have, rocket launchers and fully automatic weapons. I think it's got to be within reason, but these people, on the, not even the right, but yeah, definitely people on the right, and then, elsewhere who really believe that you should be able to have other guns. They're not crazy for believing that, but nor are the people on the left for being upset and like pissed off that we're not doing really anything about kids getting murdered in school. Yeah. So it's really hitting on both sides, understandably, but and I think a lot of people, if this does put the Senate gun bill in jeopardy to whatever extent it does, it's really sad all around, because we're at a point where it's like the one thing we could get both parties to agree on, that's potentially at risk. And then it kind of puts you almost like you're helpless to do anything about the situation. But, and it's both sides. It's always the right's like, they're trying to take away all our guns. And then the left's, a lot of people on the left are like, basically,
you don't need that many guns.
Take away all the guns. Yeah. So it's like, but the large majority, I think, of people fall somewhere in between, a lot of these issues.
But in all fairness, it's a really hard balance to strike, and it's not an easy balance to strike. And it goes back to when we originally started this podcast and said, we're not going to have all the answers. We're just trying to have the discussion out here, and obviously allow for our audience to pitch in with their opinions as well. And I mean that their opinions as well. We're looking at the law, we're looking at the decisions, we're saying, we agree with the conclusion, not with the reasoning so much. Mm-hmm. We don't think this is a very strong legal footing. But okay, we're here. Yeah. This is where we're at. But I agree with you. It's I don't think anybody should not be bothered by the recent gun violence. I agree with you that taking away all guns is not the solution, because again, once you get there, then you're giving whomever is responsible for taking away your guns, if you were to appoint someone, you're the person that is in charge of taking away all the guns, you're giving them all this power now. Mm-hmm. And anybody, like, you worked in retail and I worked in retail too. If you've ever seen some person who randomly gets a little bit more authority for whatever duty they have, you've seen them go on power trips. Imagine when that is at a scale that encompasses a full country.
Exactly.
That's how you get tyrants. That's how you get dictators. That's how you get the Cubas, the Irans of the world. That's how you get them, when you give them unfettered power. And that's why our system of government, which, it's whether you believe it's a risk or not with recent events, checks and balances used to be, this is an experiment that is going to create a system of government that survives, for centuries. So I agree that while you should always be bothered by the violence, neither extreme is the solution.
No.
Neither of them.
No. And as long as people dig their feet in on both of those sides, we're never going to make any progress.
Which makes it sad, to your point, that the one time that people are really not digging their heels in, and there's some sort of bipartisan agreement to get to a place that is closer to where we should be in this very hard topic to reach a balance on, it potentially is at risk now with the decision. When we're trying to make some progress, it feels like 5 steps back.
I wonder, kind of what scares me is, if that happens. So say like the main provisions in the Senate gun bill are thrown out, and that happens, say, repeatedly. At what point is Congress potentially going to push back and be like, why is the court deciding all this stuff? Right. And Congress has control over, to an extent, some control of the Supreme Court as well. So I don't know. It'd be interesting. But then it's like, what are they going to do? Challenge it? The Supreme Court's going to hear the case?
Yeah.
So are they just going to stop? They start ignoring the Supreme Court? I don't know. It could get really weird and scary.
Today, and today is July 26th, the House passed a bill trying to create term limits for justices.
Yeah.
Which goes to your point about the Congress having some power over the courts, over the Supreme Court. I personally don't believe that's going to go anywhere.
I don't think it's going to make it past the Senate.
Well, that's what I'm saying. Yeah. I don't think it's, even if it were to pass the House, which is possible because the Democrats who introduced the bill have power of the House. I don't think it's going to get past the Senate at all. I don't think it has a chance of arriving. I don't even think all Democrats in the Senate would agree to that. For the repercussions that it carries.
I don't either.
But I think that should be a topic that we should talk about in a different episode.
Yeah.
Because it goes to that point that you're talking about, and it also goes to the grander point of, well, there's a reason we have checks and balances, but what happens when you have Congress, which should be its own branch of government, being able to make some decisions without interference of the executive or the judicial branch, when then they get all their efforts hindered by, in this case, a conservative court. And
the reason that obviously it's so important is the Constitution, our entire government, the Constitution is a piece of paper. We put faith and belief behind it. But the moment people stop believing in our government, like, where does that put us? And the scary thing is, with the Roe or Dobbs decision, regardless of what side you were on, I believe there was a polling done. It was like 25% of people had faith in the Supreme Court, basically, as far as them being able to be impartial. Say you were pro-life, and this comes down, and all of a sudden when you got conservative justice on there to change it, you're probably you're happy, I guess. But then part of you also is like, well, it's been the law for this long, now it just finally got switched. It'd be hard for them even to be like, this isn't political. Not seeing the court to be not political. Anytime that power shift happens, and the more that happens, and the more stuff like this happens, where other branches of government, especially when parties are coming together, and stuff like this comes in conflict, I think it's putting the country in a really scary place potentially going forward. So, and I don't know.
Any erosion of any of the branches of government, in my opinion, it creates the possibility for an immense shift in people's mentality towards that. Towards, to your point, the faith in either the branch or the government as a whole. When the Supreme Court speaks, at least traditionally, is the law of the land. Because the premise has always been the court is impartial, justice is blind, and whatnot.
And that's, I think, kind of brings us back 360 to the whole Second Amendment argument. It's if at one point the branches are no longer balanced, if there aren't checks and balances, and one, the people lose faith in a certain branch to that extent, that's a problem. So again, I think the whole thought process that this could never happen, well, it almost did not that long ago. Regardless of what your opinions were on January 6th, the proceedings and how it played out, I think if it shows nothing else, there was a clear intent of staying in power despite Pence certifying the votes. There's issues you could try to litigate after that, but the way it was done and how it was, approached certainly wasn't something that we in a democracy should be encouraging. So again, people who are, I think, super anti-guns and Second Amendment and think that, tyranny would never happen again, I don't see how you can believe that. Just look at how our country was founded. It has happened.
Yeah.
And so
it is well entrenched within our history
Yeah.
and within our literally our genes as a country. One last thing that I would like to contribute to what this case, the Bruin case, was not. There's the Second Amendment as a constitutional directive does not allow to keep and carry any weapon in any manner whatsoever for whatever purpose. So it's not like just everybody is the Wild West anymore.
Yeah.
For whatever that may be worth, which is good, because going back to your point about, some people on the left are like, well, you don't need assault weapons for to hunt. That's right. That's probably not the way you want to hunt, because if you want to eat it or display it, an assault weapon is going to destroy the animal. So
and if you hunt like that, you're just an asshole, quite frankly.
Yeah, exactly. And if you do that, it's again fishing in a barrel with dynamite. But it doesn't mean that it could still be a medium where you could, like you said, have those types of weapons for self-defense against tyranny, the government, whatever the case may be. But this particular decision said handguns in particular, which are what they call like guns of like, or weapons of common use for self-defense, are the Second Amendment allows you to carry them in public. This does not mean that you can keep and carry any weapon of any kind for whatever purpose. So at least the court is not legitimizing the ability for states to not regulate how you can obtain, assault weapons.
Yeah, this isn't taking away regulation of guns at all. It's just saying that essentially New York style laws, the May issue laws, which basically prevented you from owning a firearm outside the house altogether, those aren't permissible. But they can still regulate. We'll see a lot of litigation, I'm sure, going forward as to, the extent of those kind of requirements they have to meet to get the license. I'm sure a lot of these states are going to put 30, 40 requirements and maybe hours of firearm training that you have to do that it might be pretty extensive, which I'm not saying is a bad thing.
And to be honest, hours of training at the gun range, I think they're beneficial.
Exactly.
Because, if we assume arguendo that you're getting a gun really for self-defense, it only pays for you to train on how to use that gun for the time, God forbid, you actually find yourself in the need to use it. You know how to use it.
And I think a lot of people are the same with the waiting periods. So
right.
24, 48 hours, like, one, if you have somebody where you need it right then and there, you should be going to the police anyway, right? But you do. If you get somebody who's just really pissed off and they want to kill somebody for some reason, they're really, heat of the moment situation, if they got to wait 24, 48 hours, it gives them time to cool down.
That might give you time to cool off,
Yeah, and so you're going to see, but I'm sure you're going to see litigation in that, because there are going to be states that are piling on the requirements. They're making them very extensive, I'm sure, to try to overcome this. And then the sensitive places, without a doubt, you're going to have litigation on what is and isn't.
Well, this was probably not one of the easiest episodes to follow. Not only because the legalese and everything involved was difficult, intrinsically, but also because, the subject matter was also not something that is comfortable for a lot of people. Yeah. So this one will definitely have a content warning at the beginning. Not like the one that we did for the Amber Heard video, which that content warning, if you didn't catch it, was supposed to be a joke. But I think in keeping true to the purpose of this podcast, we still think this was something that warranted a discussion. It's proper discussion and analysis of the court's decision. So we hope you enjoyed it. Jeff, any parting words?
Yeah, for those who are like more, wanting more gun control, I think it certainly can be done. Now, given, the makeup of the court, I don't know how extensive it's going to be, but, I think the more bipartisan support we can get for things, the more pressure it's going to put on the court to allow some of these restrictions. But ultimately, again, that comes down to why we need to stop digging our heels in the sand on either side, and kind of approaching these common sense gun laws that everybody can get behind, and focusing on things like that, I think, is really where we're going to see progress.
I agree. Well, thank you again for joining us. If you have any topics you'd like us to discuss, we're happy to review them. We have plenty of content that is coming your way.
No shortage.
There's no shortage of content, but we also want to make sure that we're listening to your audience, the people that are taking the time to listen to us, and if you're interested in us breaking down any particular topic, we're always happy to oblige as the schedule allows.
Yeah.
So thank you again for joining us in this episode 3. This was Lawish.